Hello, good day. My name is Noel Ariola Jr., BSHM3B, and now I am about to discuss the basic principles in obligation and contracts. What is obligation and what is contract? Obligation is a legal relationship between two parties, one of which is a creditor and other is debtor, while the contract is an agreement between two or more parties to perform or to refrain from some act now or in the future, a legally enforceable agreement. In tourism and hospitality establishments, entering into different contracts are part of the operations of the business. Once the contract is executed, the parties must abide in the terms and conditions stated therein and consider it as if it is the law that governs them. A breach or violation of the terms and conditions may give rise for the damages. In Article 1156, an obligation is a juridical necessity to give, to do or not to do. The obligation referred to in the above article is a civil obligation, meaning only those obligations which is not performed by one party, the other party may go to the court to enforce the obligation or simply to hold such person to pay for the damages, and not all that enforceable before the courts. The following are the sources of civil obligations. Number 1, law or obligation ex lege, like the duty to pay taxes and to support one's family. Number 2, contracts, obligation ex contractu, like the duty to repay a loan by a virtue of an agreement. Number 3, quasi-contracts or obligation ex quasi-contractu, like the duty to refund an overchange of money because of the quasi-contraction of solution, indemnity, or undue payment. Number 4, acts or omissions punishable by law or delicts, obligatio ex malefico or ex delicto, like the duty to return a stolen carabao or something. And number 5, quasi-delicts or obligation ex quasi-delicto or ex quasi-maleficio, like the duty to repair damages due to negligence. 4 essential elements of obligation. 1 is active subject. The active subject is a person who has the right or power to demand the performance or payment of the obligation. He is also called as the obligee or the creditor. Number 2 is the passive subject. Passive subject is the person bound to perform or to pay. He is the one against whom the obligation can be demanded. He is also called the obligor or the debtor. Number 3, the prestation. The prestation is the object of the contract. It is a conduct required to be observed by the debtor or the obligor. It may be an obligation to give, to do, or not to do. And the last is the vinculum juris, or also known as the juridical or legal tie. Other authors call it the efficient cause. It is that which binds or connects the parties to the obligation. In other words, it is the legal relation between the debtor and the creditor. In Black's Law Dictionary, obligation is a moral or legal duty to perform or not perform an act. Some legal scholars, including Frederick Pollock, claim that obligation is another word for duty. The legal sense of obligation from early Roman laws claims that obligations that are bound to vinculum juris are legal necessity between at least two individuals or parties. In Roman law, as with its successor, the civil law, theories describe a fundamental figures of obligation, torts or contracts, by the legal tie, the vinculum juris that is created between two persons. Obligations either arise from law or contracts, and they are juridical necessities. In other words, they have to be complied with. It is follows that, under the law, obligations arising from contracts and those arising from law are viewed as having the same binding effect. They are necessities and compliance which may be enforced in court, and non-compliance with the same has legal consequences. Under the principle of obligatory force, it can also be said that contracts and the law, and as a result, courts must enforce them between contracting parties. Also, courts cannot make a contract or stipulation if there is none. Article 1158. Obligations derived from law are not presumed. Only those expressly determined in this code or in special laws are demandable and shall be regulated by the precepts of the law which establishes them, and as to what has not been foreseen by the provisions of this book. When the source of the obligation is the law itself, number 1, the law creates the obligation, and number 2, the act upon which is based is nothing more than a mere factor for determining the moment when it becomes demandable. Article 160. Obligations derived from quasi-contracts shall be subject to the provisions of Chapter 1, Title XVII of this book. Article 1161. Civil obligations arising from criminal offenses shall be governed by the penal law subjected to the provisions of Article 2177 and the pertinent provisions of Chapter 2, Preliminary Title on Human Relations, and to the Title XVII of this book, regulating damages. Article 1162. Obligations derived from the quasi-delites shall be governed by the provisions of Chapter 2, Title XVII of this book, and by special laws. A quasi-delete is an act or omission by a person which causes damage to another, giving rise to an obligation to pay for the damages done, there being fault or negligence, but there is no pre-existing contractual relations between the parties. Chapter 2, Nature and Effects of Obligation. Article 1163. Every person obliged to give something is also obliged to take care of it with the proper diligence of a good father of a family, unless the law or the stipulation of the parties requires another standard of care. Article 1164. The creditor has rights to the fruits of the thing from the time of the obligation to deliver it arises. However, he shall acquire no real right over it until the same has been delivered to him. Article 1165. When what is to be delivered is a determining thing, the creditor, in addition to the right granted him by Article 1170, may compel the debtor to make the delivery. If the thing is indeterminate or generic, he may ask that the obligation to be complied with at the expense of the debtor. If the obliger delays or has to promise to deliver the same thing to two or more persons who do not have the same interest, he shall be responsible for the fortuitous event until he has effected the delivery. Article 1166. The obligation to give the determining thing includes that of delivery of all its accessions and accessories, even though they may not have been mentioned. Article 1167. If a person obliged to do something fails to do it, the same shall be executed at his cost. The same rule shall be observed if he does it in contravention of the tenor of the obligation. Furthermore, it may be decreed that what has been poorly done be undone. Article 1168. When the obligation consists in not doing, and the obliger does what has been forbidden him, it shall be undone at his expense. Article 1169. Those obliged to deliver or to do something incur in delay from the time the obligee judicially or extrajudicially demands from them the fulfillment of their obligation. However, the demand by the creditor shall not be necessary in order that delay may exist. Number 1, when obligation or the law expressly so declare, or number 2, when from the nature and the circumstances of the obligation it appears that the designation of the time when the thing is to be delivered or the service is to be rendered was a controlling motive for the establishment of the contract, or number 3, when demand would be useless as where the obliger has rendered it beyond his power to perform. In reciprocal obligations, neither party incurs in relay if the other does not comply or is not ready to comply in a proper manner with what is incumbent upon him. From the moment one of the parties fulfill his obligation, delayed by the other begins. Classes of default. Number 1 is mora solvendi, or the default on the part of the debtor of the obliger. Number 2, mora accipendi, or the default on the part of the creditor of the obligee. Or number 3, compensation morae, or the default on the part of the both debtor or the obliger and the creditor of the obligee, which arises in reciprocal obligations of the effect, which is the default of one party neutralizes the default of the other. Article 1170. Those who are in the performance of their obligations are guilty of fraud, negligence, or delay, and those who in any manner contravene of the tenor thereof are liable for the damages. Article 1171. Responsibility arising from fraud is demandable in all obligations. Any waiver of an action for future fraud is void. Article 1172. Responsibility arising from negligence in the performance of every kind of obligation is also demandable, but such liability may be regulated by the courts according to the circumstances. Article 1173. The fault or negligence of the obliger consists in the omission of that diligence which is required by the nature of the obligation and corresponds with the circumstances of the person, of the time, and of the place. When negligence shows bad faith, the provisions of Article 1171 and 2201 paragraph 2 shall apply. If the law or contract does not state the diligence which is to be observed in the performance, that which is expected of a good father family shall be required. Article 1174. Except in the cases expressly specified by the law, or when it is otherwise declared by the stipulation, or when the nature of the obligation requires the assumptions of risk, no person shall be responsible for those events which could not be foreseen, or which, though foreseen, were inevitable. Article 1175. Usurious transactions shall be governed by special laws. What is usury? Usury, as defined in Black Law's Dictionary, is the charging of exorbitant and unconscionable rate of interest higher than the interest allowed by the law. In layman's term, it means loan sharking. Article 1176. The receipt of the principal by the creditor without reservation with respect to the interest shall give rise to the presumption that said interest has been paid. The receipt of the later installment of a debt without reservation as to prior installments shall likewise raise the presumption that such installments have ever been paid. Article 1177. The creditors, after having pursued the property in possession of the debtor to satisfy their claims, may exercise all the rights and bring all the actions of the latter for the same purpose, save those which are inherent in his person. They may also impugn the acts which the debtor may have done to fraud them. And the last, Article 1178. Subject to the laws, all rights acquired in the virtue of an obligation are transmissible if there has been no stipulation to the contrary. That's all, and thank you.